Yeah, good morning once again. Today's class we will focus on design rights. What are the design rights and how can an engineer put it into practice? So design rights. So what does that mean? So you are part of a design team in a company, and you have made a wonderful design for a particular product. Say, for example, a mobile phone. So, how will you prevent others from copying that particular design? Because you have put a lot of research into that design, into the research, and finally you have made that particular design, which is quite attractive and which is an ergonomic design. Say, for example, then how will you prevent others from copying or making unwanted advantage of your design, right? So that is the design rights. So in other way, what are the rights that the owner of a particular design has uh, for a particular design? So for that, what are the things that he should do? In fact, he should register the design. That is the first and foremost thing about design is whenever you have a design finalized, you must register that. So these are the things that we should be taking care of while we talk about design rights. So as we go through the slides, I think the matter will be more clear to you. So what is a design right? If you have created a new design, it is worthwhile considering registering it to effectively prevent other from copying or exploiting your design. So you can prevent others from copying or exploiting your design. So that design will be yours. And so if you register that, so that is the purpose of registering a new design. So a registered design is an excellent and cost-effective tool to protect your rights against copying and counterfeiting. So design is the overall appearance of a product. Design results from one or more visual features, say shape, configuration, pattern, and ornamentation. Ornamentation means decoration. When the visual features are applied to a product, they give it a unique appearance. So altogether, that product will be a unique product. So you will have a first impression. Oh, yeah, this product looks fantastic, wonderful. So how do you reach at a conclusion that this is a wonderful product? Maybe looking at the shape, maybe looking at the configuration, maybe looking at the pattern, and maybe some sort of decoration in that product, isn't it? Say mobile phone or laptop, maybe car, maybe any product that you use. No, it will have a unique design features. Design must be registered to be protected. That is an important thing. Designs must be registered. Upon registration, the owner of the design will have the exclusive right to apply the design to the product for which it is registered. Registered designs protect the way things look rather than their functionality. Basically, this considers the look and feel, how it appears to the users. So that is what the design normally means, not the internal matters. Registered design is a shape, configuration, pattern, or ornament, or composition of lines, or color, or combination thereof applied to any article. Article means any object, whether two-dimensional or three-dimensional, protected under the Designs Act 2000. So there is a Designs Act in India, which was established in the year 2000. So all the design rights are awarded, are recorded based on this particular Design Act. So that act is known as Designs Act 2000. The old saying goes, the first impression is the best impression. So in the case of a product, the first impression is inadvertently made by the appearance of the product before the user even explores its functionality. Say, for example, when you see a mobile phone or when you see a laptop, when you see a car, new car, now first thing that comes to our mind is the overall appearance before we look or explore or use the features present in the particular product, how it, what is the overall look that it gives the users. That is the first impression. In this era of creativity, aesthetics, and presentation, the overall design and visual appeal of any product is very significant. The purpose of design registration. The objective of the Designs Act is to protect the unique visual appearance of a product. So you have created a product, and you should have the right to keep that particular design as yours. The act also aims to give the owner exclusive rights to apply the design to mass produced goods for a limited time. Limited time in the sense there is a time period for which this design rights are provided. We will see the details. Industrial design protection is provided for a shape, configuration, surface pattern, color, line, which when applied to a functional article produces or increases aesthetics and improves the visual appearance of the design, be it a two-dimensional or three-dimensional article. As per Indian law, as we have already mentioned, under the Design Act of 2000, industrial design protection is a type of intellectual property right. You might have heard of
Hello, sir.
intellectual property right. Yes.
Sir, Sanjuta is not able to join, sir.
Yeah, ask her to rejoin.
Okay.
As per the Indian law, under the Act of 2000, industrial design protection is a type of intellectual property right that gives the exclusive right to make, sell, and use articles that embody the protected design. Why should one register the industrial design? So what is the need for registering the industrial design? Industrial design means the designs which are made in the industries. Okay. So the outer appearance of a product makes it visually more appealing and attractive. This acts as a value-adding aspect, which in turn increases the marketability of the product. So marketability of the product always depends upon the looks and feel it provides, how attractive it is, how appealing, how visually appealing the product is. So that decides the marketability of the product. This leads to the need to protect your creation from third parties' use. We want to prevent some third parties or some companies to use your design in order to prevent them from taking advantage of your rights in this world of competition. So in many cases, the design itself becomes the identity of the brand. So design becomes the identity of the brand. Many example you can say, we'll quote the examples in coming slides. When a product's design is protected, it stops illegitimate products from destroying the brand's efficacy and safety. Protection of industrial designs also encourages creativity in the manufacturing and industrial sectors. So examples of registered designs. A wide variety of items can be registered under the Designs Act in India. So items ranging from cutlery. Cutlery means your spoon or fork or knife that you use for at the dining table, even starting from there to even dress material, dress designs, a particular design of a dress, even that can also be registered as a design in India, provided it is original. Some of the most famous examples of design registration are Coca-Cola bottle. You might have seen the Coca-Cola bottle, and it has a unique shape and contours of and the design of the iPhone, iPad, iPod, and the shape of the Volkswagen Beetle. This is a vehicle, and the Mini Cooper car. Not only this, all the cars design, unique designs, the company will register so that others will not be able to copy it. Others will be prevented from copying the original design. So these are some of the examples where the owners of the design, the company, original company that produced the design, have registered the design, and that particular design belongs to the registered parties. So others cannot use them without the permission. No, they cannot use, of course. A design registered in India under the Design Act 2000 is referred to as registered design. So what we mean by registered design is a design of anything. As we have quoted examples, a design registered in India under the Design Act 2000. So when we register a particular design, when we approach the registered office, this act is coming into force, the Design Act. So probably patent office, if you look at patent office, the head office is Calcutta, and in the nearby is, I think, Chennai, Mumbai, Delhi, Kolkata. These are the major patent offices in India. So those offices will be providing all the help and support for registering the designs. So when can you register your designs? So you have a particular design. So can you register that particular design? Or when can you register that design? So for a design to be registered under the Designs Act, it must satisfy the following 6 conditions. So what are the 6 conditions through which you can verify whether a particular design can be registered or not under the Design Act 2000. The design, first of all, the first point, the design should be new or original, not previously published or used in any country before the date of application for registration. It should be really novel, really original. So it is not a copy of some other designs already prevailing in some other part of the country or outside the country. So the first requirement is design should be totally new or original. Then you can go for design registration. Second one, design should relate to features of shape, configuration, pattern, or ornamentation applied or applicable to an article. So it should relate to the shape, it should relate to the configuration, it should relate to the pattern or decoration or ornamentation applied or applicable to an object. Article means object. Thus, designs of industrial plants, layouts, and installations are not registrable under the Act. So, designs of industrial plants. So, you have a plan, industrial plan, how the machines will be, placed, or how the machines will be laid. What is the layout and installations? No, these kind of things are not registrable. That cannot be registered. Registrable means that can be registered. Third one, design should be applied or applicable to any article by any industrial process. So it should be produced by an industrial process. So then only you can apply that registration to that particular object. Normally, designs of artistic nature like paintings, sculptures, and the like, which are not produced in bulk, which are not produced in through some industrial processes by any industrial process, are excluded from registration under the Act. They are excluded. So artistic objects like painting or sculptures. Sculpture means some sort of creation that you carve from metal or stone or clay. Those kind of things are not produced by any industrial processes. So they are excluded from the registration under the Designs Act 2000. So third point is design should be applied or applicable to any object which is produced by some industrial process. The fourth point is the features of the design in the finished article should appeal to and are judged solely by the eye. So it should be visually apparent that this is what the design is. So this implies that the design must appear and should be visible on the finished article for which it is meant. So the design, if you want to register, it should be totally visible, and we should be able to judge the particular design by eye. So that design only can be registered. So fifth point, by any mode or principle of construction or operation would not be registrable design. Any mode or principle of construction or operation, so would not be registrable design. Sixth point, the design should not include any trademark or copyright. So trademark, you would have seen letters TM within a circle. So that is trademark or copyright. So any design which has certain trademark or copyright rights associated cannot be registered. So these are the 6 points through which you can verify whether a particular design can be registered or not. So benefits of design registration. So all documents pertaining to a registered design are maintained by the patent office. As I told, Kolkata is the head office and Chennai is the nearby patent office. So all documents pertaining to a registered design are maintained by the patent office to put competitors on notice about registration of a design. So when you approach the patent office for registering our design, so they will publicize it and they will issue notices to, or they will make it available to all the concerned competitors, concerned people, so that they can raise any objection in this regard, if at all. So a registered design provides the creator exclusive rights over the use of the design for a period of 10 years. So this is what is normal in India. The initial period of design protection is for a period of 10 years, and that can be further extended for another period of 5 years. So altogether 15 years. So in case of infringement or piracy of a registered design, the owner of the registered design can seek legal remedy under the Designs Act. So the owner of the design will get legal protection under the Designs Act if somebody copy or make unwanted use of his design, his registered design in their products, in the marketability of their products. They can, the owner of the original design can seek legal action under the Designs Act in India. So these are the benefits of design protection. So protection rights are provided for a period of 10 years initially, renewed for another 5 years, as we already mentioned. To obtain design protection in India, the same has to be registered. So the same design has to be registered, only then we will get the protection. How to obtain industrial design protection? An application is to be submitted to the design office with the desired designs with a classification code and a description of the design. So they will have which category it belongs to, vehicle or household item or dress material or cutlery. So that is a classification code, which category this design belongs to, and description of the design. The application then goes through an examination process, after which the applicant receives a communication from the design office regarding any objection, if at all present. So you have to file the application, and they will publicize it, and after certain period you will get communication of the design office regarding your application, regarding any objection if somebody has regarding this design. Because if you have copied design from somebody else, then definitely other company will point out this is not an original one. So they can, so if we have some objection to a particular application, we can raise our concerns. So that will go to the design office, and the design office or patent office will communicate that thing to the corresponding party. After rectifying the application based on the objections and responses from the design office, the application will be granted if all the requirements are met. Once granted, and if there is no objection from any third-party sources, the design becomes exclusive to the owner for the specific time period. As we mentioned, initially for a period of 10 years, and after that, extension for a period of another 5 years. So that was all about design, industrial design protections. Now, trademark. Trademark is a word or symbol used by a business to distinguish its goods or services from other competitors. Business names, brands, and logos can easily be trademarked, filing an application online. Once a trademark application is filed, the trademark applicant can begin using the TM signal, TM symbol with the brand. So on registration of a trademark, the mark becomes an asset of the company and is protected against misuse under the Indian law. Thus, to protect a brand or business name from being copied by others, the inventor must apply that for trademark registration. This TM is appearing everywhere. No? Every product, everything that you buy or purchase, this TM trademark will be there. Another term is copyright. So copyright is a right to ownership and enjoyment given by the law to creators of literary, dramatic, musical, artistic works and procedure, and producers of cinematograph films and sound recording. So this is where we use the term copyright. Say if your creation, if your design, so-called design is pertaining to literary activity or dramatic, musical, so you are creating a new music or composing a new music, so that can have copyright protection. It's a bundle of rights comprising of rights to reproduction, communication to the public. So if you are the composer of a particular music, you can reproduce that, you can communicate to the public, you can adapt, and you can translate the work from one language to another language. So whatever you want to do, you can do that, and somebody else cannot do that because you have the copyright of the particular music album or musical creation that you have made. Difference between patent protection and industrial design protection. In some cases, a question may arise as to which type of protection to opt for, industrial design protection or patent protection or copyright protection. So industrial design we have seen in details, patent we have mentioned, copyright also we have seen in a little bit detail. So we will see the difference between patents, industrial designs and copyrights. So what is the difference? So here in the table, if it is visible to you, you can see 3 columns: patents, industrial designs, and copyrights. So along the row, first row, what can be protected. Second row, duration and region of protection. Third one, when to apply. So first one, what can be protected. So under patents, a technical enhancement which is novel, unique, and useful. So a technical invention. Say, for example, a new processor, a new memory technology, or a new some technological advancement. Even algorithm also you can patent algorithm, not as such, but the individual steps in the algorithm you can patent. So that is what patent, what can be protected under patents, a technical enhancement which is novel, unique, and useful. So industrial designs, novel, ornamental, or aesthetical appearance of any article of use, any object, any shape, any design, any looks, any outside appearance, that belongs to the industrial design. Design of a bottle, design of a mobile phone, a design of a cake, of a car, design of a dress, design of any item which we use, a mouse, keyboard. Those things you can protect under industrial design. Underlying technology you can protect through patent. So what is underlying technology? What is the technology you're using? Your memory, your device, particular device. What is underlying technical details that you can patent? Then third one, copyright. What can be protected under copyright? Any, as we mentioned, any literary object, namely artwork, poetry, films, books, music, books. When you write a book, you can copyright. You can have copyright protection. Music, photography, etc. It can be protected. So duration and region of protection. So patent, 20 years protection in the country of filing with no extension after 20 years. So altogether you get 20 years. So industrial design, 10 years protection in the country of filing and can be renewed once for 5 years. Copyrights, worldwide protection for the lifetime of the creator plus 60 years. So that is the duration of copyright protection. So when to apply patents? Before launching product into the market, you must apply for patent, not after launching. Industrial designs, before launching design into the market. Copyright, you can apply at any time. So that is a flexibility with copyright. You can apply for copyright at any point in time. So that is the detail of patent, industrial designs, and copyrights. So in today's class, what we have actually seen is design rights given to the author, given to the owner. So whenever you have a new design, that has to be registered because otherwise people will copy it. Then what is the procedure for registering it? What are the advantages you get as an owner of the design when you register it? And what is the criteria which you can use to decide whether a particular design can be registered? And we have seen some of the examples of registered designs as well. So I think the matter is clear. If you have any doubt, you can ask me. So that's all for today's class. Now I think 10 minutes are there. You can have some interaction. So thank you.